This is Mark Strassman, reporter with Etopia Media's Entertainment Technology World. We're about to speak to Jim Pickrell, who's the president of Brand X. He's in Santa Monica. I'm in Studio City. Welcome to Etopia Media's Entertainment Technology World.
Well, thank you.
Why don't you tell us briefly about how you became the president and what the history, the backstory is on Brand X before you achieved the greater notoriety of in front of the Supreme Court?
Well, basically, it started as a home business. The Brand X originally started in my living room, and we bought a bunch of computers and got a network connection and did a lot of research about the technology and the internet and networking.
When was that?
Well, that was originally towards the tail end of 1994, beginning of 1995.
Okay, go ahead.
And so we set up a network and connected it to the internet and started selling accounts. And these were basically dial-up accounts, so people would dial up and check their email. And even the web was pretty new then, but anyway, it seemed like a good business, and that's how it got started. And at that time, I guess that's when I became president of the company, because I started it.
All right. Along the way, the cable companies and the phone companies got into the internet access business. How did that affect your operations?
Well, in the beginning, it didn't really, because at the beginning, the rules were that the telephone companies, well, the cable companies weren't involved at all, and the telephone companies, when they finally did get involved, they didn't completely abuse their position as a monopoly telecommunications provider. So we could buy telephone lines, but they could buy telephone lines, and they're fundamentally a lot less efficient than we are. So as long as everything was kind of on a level playing ground, they were charging a lot more than we were, and nobody was really interested in doing business with them.
How did that change?
Well, what happened was a couple of things. One is they were under a lot of pressure in the beginning. The local phone company here is Verizon, and they were at that time GTE, and they were trying to merge together. So when they tried to merge, they were being checked out by the federal government, and they felt a strong responsibility not to violate antitrust laws and that kind of thing. Since then, the administration has changed, and the people in charge have changed. The people at the FCC have changed. And we got into a friendlier environment that kind of encourages them to exercise their monopoly powers. And because all of our communications pretty much have to go through the telephone companies, we're at their mercy. If they're playing fair, then we'll do well. If they charge us 3 times as much for line access as they charge their own in-house operation, then we're put at a disadvantage. And that applies whether it's on telephone lines or DSL lines or whatever. Basically, we rely on fair pricing, uniform pricing for line access if we want to be able to compete in the market.
Okay, and then as the cable companies became the dominant provider of broadband access, what kind of attempts did you make to work with them to provide your service over their cables?
Well, we did the same thing with the cable companies that we did with the telephone companies, which is, we approached them, we talked to their lawyers, we talked to whoever we could find to talk to. I got some lists from the California Public Utilities Commission of people who are involved in affairs there, and we contacted them and told them that we were interested in buying transit rights over the lines, that we would be happy to pay for the service, and that we'd like to try and enter into negotiations for interconnection. And they told us to go pound sand.
Okay, now the reason you were asking them is because you looking at the cable networks saw a telecommunications system, right?
That's right, and if it's a telecommunications system, then under law you should be able to interconnect. It's the same thing if you have small telephone companies. They don't allow a large telephone company to refuse to interconnect to another telephone company. I mean, I think you can see why that would be bad for society to have the telephone systems fragmented like that. And there are laws about this, and it has to do with being a common carrier and the Telecommunications Act and all of that. And basically, if you have a telecommunications network, you should be able to interconnect to any other telecommunications network.
Okay, but when the cable companies, and especially their lawyers, look at their cable network, they don't see a telecommunications service, they see what they call an information service. Is that right?
Well, that's certainly one of the stories that they've gone with. The other one is that they see a cable service as opposed, and so there are different people who would argue different things. I think their current story is that it's anything that's digital is data. If it's data, it's information. If it's information, it's an information service, and therefore it's not a telecommunications service, and therefore the common carrier obligations don't apply. That's the story they're working with right now.
But in fact, the data can only be carried over a telecommunications network. Isn't that right?
Well, I think that's right, and I think that sometimes people get lost in kind of all the lawyer talk. Just common sense would tell you, if you look in the dictionary for the word telecommunications, it has something to do with communication over a distance, and certainly whether you're communicating like we are by video conferencing or by making a telephone call, I think it's more or less the same thing. And the Telecommunications Act itself says that the nature of the transmission medium does not determine whether or not it's a telecommunications service. And I think just to, the entire premise that once something becomes digital, it's no longer telecommunications and is exempted from the Telecommunications Act is just completely ridiculous.
In fact, as all telecommunications goes digital, all telecommunications will be digital.
Well, I think they are already, and that's certainly the point that the telephone companies are interested in, because if they can get away with this, then what they will say is that every form of communications is digital, therefore every form of communications is completely deregulated, and when they look at deregulation, what they're interested in is not a 5-cent increase in the per minute call rate or something like that. They really want a free-for-all where they can do anything they want. And when you're in a monopoly situation, that can really be abused. And the history of abusing this is huge, and the cable companies go in the same boat. Whenever they get in a monopoly situation, they start jacking up prices and providing lousy service. When new technology comes out, they don't want to use it, and they won't unless they're forced to, and the only way they get forced to is by somebody else doing it. And once they start feeling that they've missed the boat and somebody else is making some money and they're left out of it, that's when they adopt new technology. And that's really, if the government wants to kind of energize private business and harness it for the benefit of the public, competition is the way to do it, not setting up big monopolies. I think that's where the FCC has really gone wrong, and that's what we're challenging in this court case. That's the real reason for the whole thing. Okay,
let's take a little history of the court case. After you were turned down by the cable companies, where did you go to court? What did you ask for?
Well, I guess it goes back a little earlier than that. This had been contemplated for years before it was actually filed. And where it started was with the Portland cable case. And in that case, the city of Portland was dealing with the transfer of the cable monopoly franchise from some local company to AT&T. And the city said, for the benefit of consumers, if we let you do this deal, which will create a bigger monopoly, we want to create some competition too. So we're going to require open access on the internet side if you want to have this license transferred. And AT&T, of course, challenged this in court. They didn't want competition, and they were victorious in court, which we saw as a short-term defeat because we had certainly been agitating that cities should require this, and the court said they couldn't. The reason the court said they couldn't had to do with some details of the law, and the law says that as part of a cable franchise agreement, the city cannot require a telecommunications service be provided. And the court very clearly, and it was the basis of the entire ruling, the court ruled that the cable modem service was a telecommunications service, and therefore the city could not provide it. So we looked at this and we thought, well, that's a defeat right now, but somewhere down the road, somebody ought to take this up and run with it, because if it's a telecommunications service, then they have common carrier obligations, and somewhere down the road we'll want to challenge that in court. So then fast forward, and eventually the FCC they announced a proceeding. The proceeding was, it's kind of funny, they're like an investigation, but they start out with the conclusion of the investigation, and they sit around and investigate for a while, and then they rubber stamp their own initial conclusion.
Let me put in 2 points. One, if you could move a little to your left, just a little bit, we'll get more of you in the picture. That's good.
Oh, sorry.
That's good there. And what you've just said is reminiscent of what the Red Queen says in Alice in Wonderland or Through the Looking Glass: verdict first, trial later.
Well, that's exactly it, and it's a fundamentally ludicrous position. It's the kind of thing that makes sense if the people making the decision have already made the decision and potentially have a vested interest in what's going on, and certainly, the big phone companies and cable companies are big political donors, and they carry a lot of weight. What the announcement was is that they were going to investigate whether or not cable systems, cable modems specifically, and cable internet, whether or not that was a telecommunications service. And the tentative conclusion was, no, it wasn't. And then they made the formal conclusion, and at that point we filed in court to appeal that.
Okay, and that case made it to the Supreme Court on March 29th of this year.
Yeah, that's right. It started out going through the Ninth Circuit, which is the West Coast federal courts, Washington and California.
Right.
And the hearing was actually held in Seattle. We were victorious on that one. And then the cable companies and the telephone companies and the FCC appealed, and they asked for what's called an en banc hearing, which means only three judges had heard this appeal originally, and they wanted the entire 32 to listen to the case and rule against them. And the 32 judges voted 32-0 that they were not interested in overruling that. So then the FCC and the administration in Washington filed an appeal, and that went to the Supreme Court, and that was heard, I guess, last Tuesday, and that's where we're at right now.
Okay, but before we go on, I want to talk a little bit about who's on which side here. The telephone companies and the cable companies seem to be mortal competitors for broadband wired connections, and they are constantly downplaying each other's offerings on television. And yet, in the case of Philadelphia trying to establish a broadband municipal wireless network, the cable companies and the phone companies got together and went to the Pennsylvania legislature to put the cities out of that business of offering Wi-Fi. And now in your case, the cable companies and the phone companies, who are strong competitors against each other, have united with each other and the government regulatory agency in charge of adjudicating these issues to try to stomp on your proposal. Isn't that about it?
Well, yeah, I mean, what you're saying is right. And the cable companies and telephone companies do try and steal each other's customers. I think that's great. I think that consumers benefit every time there's even a small amount of competition. But what they'd really like to see is a duopoly, where two large corporations control the internet and all communications of every type in every market. And so you would have, like in my neighborhood, you would have a choice between Adelphia, which is just terrible, and Verizon, which is just terrible. And I think that while they do have at each other a bit, they all realize that they'll be better off by getting rid of all third-party competition, because a lot of little companies are hungrier and also have roots in the community and a lot of other advantages. And the way that these guys can stay in power is by just sort of using the legal apparatus to shut down all their competition. And then, they can both kind of figure to split the market, and they come out way ahead. It's a lot easier for big companies to collude, too, when there's only two of them. If you get 4 or 5 or 6 or 100 or 300 companies, it's very hard to set up a collusive agreement. I remember in Los Angeles when cell phones first came out, there were only 2 cell phone companies, and they both charged really high rates, and they both charged exactly the same rates. And this was just this amazing coincidence that these guys, they never spoke to each other, and they had no agreement, but their rates were identical. And as soon as you introduced even a few more companies, you got a much better situation. You get more minutes, you get more long distance, you get all these advantages, if we bring it back down to two cell phone companies, you're going to have the same kind of problems. And it's something that spans across economics. I mean, in every market, whether it's for, airplanes, like, I saw a really interesting parallel in that recent movie about Howard Hughes, where Pan Am was looking for the government to guarantee them a monopoly. And the same thing there in airplane markets. If you have only one airline coming into a particular airport, you get very bad rates. If you have 10 or 15 flying a particular route, then you get much better rates, much better competition. I mean, it's just obvious that competition is the way to go.
Let's talk a little about the historical irony here. In the mid-'90s, when you got started, there were a lot of little ISPs pioneering the internet, and neither the cable companies nor the big phone companies were involved in it. But when the market got big enough, they came into it, and from what you're talking about now, there's a very real possibility that they will monopolize it or duopolize it to the exclusion of the specific individuals as well as the type of companies that pioneered the internet in the first place.
Yeah, a lot of internet companies like ours were started in somebody's living room or somebody's garage, and people who did them felt like they were innovating. They were providing a service that wasn't currently available. And I mean, for us in the beginning, the biggest sales problem was just convincing people that they needed the internet, that it was useful, because a lot of people didn't see that. We did. And the telephone companies were definitely not interested in it. We were going for several years before they really decided that was something. That's because big monopolies are fundamentally followers, not leaders. They do not innovate.
Okay, talk about the arguments that your side made in the Supreme Court on your behalf on March 29th.
Well, it's interesting because there are a couple of different issues, like a lot of legal things. There's like the big story, which is, do we like competition or do we hate competition? And everything else, the who's on what side is pretty much divided on that issue. If you think competition is bad, if you're a big cable company, if you're a big telephone company, then you'd be in on the appeal. So that's the big issue. But the actual legal issue, what's being decided right now, are 2 points. One is, do cable modems contain a telecommunication service? And our answer is yes, they do. The other issue is the court obligated to follow the precedent of earlier decisions? There's a system in our courts where if something comes up that a court has already ruled on, they're supposed to be consistent and follow that precedent. Well, that was the deciding thing in the original Ninth Circuit Court hearing. I think the turning point there's this legal concept of what they call Chevron deference, which doesn't just mean you should bow down to the big energy monopolies, but what it means is that the courts should defer to an agency that has specialty in a particular area if what they're doing is sort of plausibly within their legal mandate, what they're required to do by law. And that doesn't require that the court necessarily agree with it, but it says that you really shouldn't try and second-guess the agencies if they're kind of, to some extent, following the law. And there's this requirement of ambiguity for that to apply at all. Well, what we were arguing, and what the court agreed, is that this had already been decided in the Portland case, the issue of whether or not cable modems were a telecommunications service. And the FCC was arguing that, since they were the experts on this subject, that if they ruled that cable modems were not a telecommunications service, then that would be the final word. And so what happened in the court hearing, and this is the turning point to me, was one of the judges asked the attorney for the FCC and the cable companies, so what you're basically telling us is that if you folks at the FCC don't agree with one of our court decisions, you can just ignore it. And the FCC guy said yes. He was kind of mumbling around about it, but yes was his answer. And the judges were like, okay. Because I think that the courts feel that they have an important place in the entire legal process. And the result of that decision would be that there would be no way to appeal a wrong decision by the FCC. If they weren't following the law, they would be the final authority and there would be no way to challenge them. So I think that it was unrealistic for the FCC to think that that story would fly.
Does that mean more generally that the argument here is between administrative agencies and the court system, so that if the FCC is entitled to overrule court decisions on its own say-so, then the FDA or the other regulatory agencies ought to be able to do the same thing, and they are above the law then under that reading from the FCC?
Yeah, that's exactly right. That's what they're shooting for. And this is a bad idea because we need to have balance within the government. You can't just have the president and the administration making all the rules with no checks and balances. And this isn't a partisan Republican-Democrat issue. I think everybody agrees that a system of checks and balances is the fundament of our Constitution and what holds our government together. And they're really trying to overturn that. They really want to set up a system where the executive branch has veto power over the courts, and that's not how the system works.
Interestingly, this same issue is coming up in Congress right now, with certain members of Congress saying that these judges have no right to do what they're doing, and we're going to tell them what to do. Essentially, you're saying that the FCC's argument was that these judges have no business making these decisions. We're going to tell the country what to do.
Yeah, it's kind of funny because they also want to preempt over Congress, too, because realistically speaking, if someone really wants to totally deregulate telecommunications, what they need to do is they need to repeal the Telecom Act. And there are some, the telephone companies are bought and paid for, quite a number of legislators and senators, and they are moving right now to try and make that happen, to totally deregulate telephones and telecommunications altogether. I think it's a really bad idea, but if everybody thought that was a good idea, then passing the laws or repealing the law is the right way to do it. What the FCC has tried to do is an end run by redefining the word telecommunications to not include anything digital, and that's just silly. That's the wrong way to do it. And whether or not you agree with our position, I think the issue there about changing laws by redefining words, I think everyone should agree that that is a bad way to do things.
Well, of course, going back to Lewis Carroll and Through the Looking Glass, or Alice in Wonderland, I'm not sure which one, Humpty Dumpty says, when I use a word, it means precisely what I intend it to mean. It's simply a matter of power. That's what Humpty Dumpty says about that.
Well, there's an application here of that, because you have a couple of things to define what the word means, and what we have to remember is that telecom and telecommunications is defined in the Telecom Act and also in the debates and discussions as that act was adopted. I don't know how familiar everyone is with that, but the Telecom Act, the 96 Telecom Act came up after the breakup of AT&T. The fundamental purpose of the Telecom Act was to encourage competition in telecommunications. It was not the total deregulation and setup of monopoly for telephone companies act. And for them to pretend differently is just ridiculous. So to the extent that someone was declaring what words mean, it should be interpreted consistent with the intention of the law, which was to encourage competition.
Okay. What are you doing there while you're waiting for the Supreme Court to act in terms of your business activities?
Well, things are pretty difficult for us right now. We're very determined, so unlike most of the competitors that we were going head-to-head with in 95 or 96, they're all out of business, and there are only a couple of the local companies here in Los Angeles that are still active. We're still doing our best. It's very difficult because for us to reach customers, we need to be able to, in some way or other, transit some of these lines to get to those customers. And that means going through a cable company, going through a telephone company, going through something. I mean, who knows, maybe you could find a way to go through cell phones. I don't know. Realistically now, the things that are technically practical are cable and telephones. The cable networks are utterly closed to us. The telephone networks, in theory, are open, but, they've got some not very tricky ways to prevent us from being competitive there. The first thing they do is massively overcharge us for the line, so the price that we pay for line access, which is just one element of our service, is 2 or 3 times, when you add up all the charges, it's 2 or 3 times what a customer can go directly to the telephone company and buy the entire bundle of services with internet and email and websites and everything. So, I mean, if you're paying, $40, $50, $60 a line net charges per customer, and then turning around and trying to sell the service for $30, well, you can't make that up on quantity. That's not going to work. And so that effectively locks us out. It prevents us from signing up a lot of consumers. Now, we provide other services, and there are other things that we can do to compete, but we're fundamentally being treated unfairly, and we're fundamentally being overcharged for the services. What we want is a level playing ground, and if we get that, we feel we can compete. Right now, we don't have a level playing ground, and that's making things very difficult. So, to some extent, we're kind of in a holding pattern, hoping that some avenue will open up that will give us a fair chance to provide services to customers.
Okay, now on a companion website here, Broadband Wireless Access World, we've done several interviews with Diana Neff, who's the CIO of Philadelphia. And last week, Philadelphia announced a plan to build a municipal Wi-Fi network that the city would build and use a cooperative wholesale model and allow individual ISPs to provide service using their network. Is that something that would help you if you were in Philadelphia or even in Santa Monica managing this in Philadelphia?
Yeah, we'd love to be in on things like that. There's also been talk in some areas of putting in fiber networks, and I know I've talked to some people in Milwaukee that were interested in that kind of thing. I kind of have mixed feelings about that, but I don't think it makes sense to have a separate set of wires for every company that's in a market. Let's suppose you have 25 internet services that are really active in the Santa Monica market. Does it make sense to have 25 sets of wires on the telephone poles? I think not. I think what makes sense is to have one company providing the wires, whether it be a city-operated business, and it's the same thing on wires. And, it makes sense to centralize that where the natural monopolies exist, but at the lowest level that you can create competition, you should. So the company that does that, the company that's either providing the wireless telecommunication service or the fiber telecommunication service or whatever, should not be in the internet business, should not be in the telephone business. They should just be providing the wire service and let everybody else buy access to it and compete to see who can provide the best bundle of services over those wires. As long as the municipal system is operating along those grounds, I think it could work out pretty well. It certainly wouldn't be hard to do better than the telephone and cable companies are doing, because if you look at the markups that the telephone companies are charging for DSL right now, I mean, it would cost them a few dollars a month for the line access on a DSL line. They're turning around and selling that to us, just the line, never mind the backhaul and all the back-end charges, for $34. Now, how do you justify a 10 times markup on a telecommunications service? That's just ridiculous. I mean, any kind of system that was set up would have to be better than that.
Okay, let's talk a little bit about customer experience and innovation. SBC, which is the Verizon of the rest of California that isn't covered by Verizon, has a project called Project Lightspeed, where they're promising fiber to the node in the neighborhood, fiber to the premises, fiber to the home, that they say will deliver astronomical levels of speed. If they win this case and they don't have to go ahead competing with you, is it likely that those plans for next generation internet connectivity will be put on hold, or will they go ahead just to be nice to customers, or what do you expect will happen in that?
Well, I don't think doing something just to be nice to customers is in their vocabulary. But the phone companies operate on simple economic models. If something makes money for them, they'll do it. They see monopoly power as a long-range benefit. So if something makes them money and extends their monopoly, that's good too, because the monopoly will help them make money next year too. Do they innovate? No. And as far as things like fiber, the thing that will finally drive that in is as the maintenance costs on copper become too expensive and as the cost of fiber comes down, they'll gradually replace things. Are they willing to do it right now? No, clearly not. And the only reason they have announced these different projects, those have two purposes. One is they make good politics because they can dangle that in front of the FCC and say, if we're forced to allow competition, if we're forced to let other companies benefit from our fiber lines, we're not going to install them in the first place, which is just hoo-ha, because if they can charge for it, they will do it. The second reason that they've announced these projects is to discourage other people from doing it, because there have been other groups that have talked about installing their own fiber lines. In fact, that's something that we ourselves have been aggressively looking into to see if we could make an economic model for that. And we actually if we lose this case, we may try and do that. That's a difficult question in itself. But what the telephone companies have done is they announce a project and they announce that they have, umpteen $1 billion, and basically anybody who tries to build anything, they'll come in and squash them. So if you were to start in San Francisco or Milwaukee or someplace putting in your own fiber lines, then they would have their little project come in and put fiber lines parallel to yours and wipe you out. And it's kind of like bugging, because they don't have to actually do it. Just the knowledge that they have 2 or 3 houses with fiber and that they're willing to squash anybody who walks in their backyard, that scares off investment capital, and that prevents people from moving forward. So the result of these supposed innovations and these supposed projects is to completely crush competition and prevent innovation. And the proof is in the pudding. I don't know too much about SBC's projects right now. I know that Verizon made all kinds of announcements and wired up a few houses in the Long Beach area. That project has been pretty much called off. We kind of get inside word from that when someone came out to my home the other day to repair problems that we were having after the rain, because the telephone, the DSL service and everything goes out completely every time it rains. And the guy they sent out, he had been working on that project, and he and all his colleagues had been laid off. So despite what you may be hearing from the people that issue the press releases, the reality is they've installed a few lines and they're done, and that's it. That's over, and they're not interested in pushing that forward.
Okay, before we wrap up, maybe you could address sort of the whole configuration here. If citizens get their information increasingly over digital networks, and those digital networks are controlled by definition, if they're digital, by a duopoly, what's this going to mean for the functioning of democracy and the rule of law?
Well, there's a lot of issues here. I think the fundamental issue is competition, and whether that be competition in economics or competition in political ideas. I think the fundamental idea of the American system is the idea of kind of that everything should be a free-for-all, and that you should have a free-for-all of ideas, that ideas should succeed by the fact that people hear what someone has to say and they're persuaded, they agree with them. In order to have that work, you need a lot of voices. 2 voices is not enough. The same thing goes for economics. In order to have an economic system that really works, you need to have a lot of choices, and it's the system of having choices that allows consumers to kind of vote with their money, to vote with their feet about who they think is doing a good job at meeting their needs. The guy who's running a monopoly, he's always going to tell you that service will be better if he has his monopoly, and he'll always be coming to you telling you how if he can just raise his rates a bit, that will encourage innovation and it will just create a wonderful system. And it's just nonsense. We've had, in the 20th century, a major face-off between a system that encouraged monopolies, which was under the Soviets, and a system that encouraged competition in economics and ideas. That's the American system. And it's just amazing to me that the current administration would come down on the other side of this issue, that they would think that competition is a bad thing. I think that if you centralize control of communications in 2 companies, they're going to find a way to abuse it. And we've seen a lot of that so far. We'll see a lot more of it. There's certainly even a larger problem when you see that these same companies are also the companies that are involved in distribution of information and news, because one of the big players in this entire dispute is Time Warner. And Time Warner with CNN and Time Magazine and a lot of other things besides Time Warner Cable. And I think that, it's great to have them in the market and competing, but in order to keep them honest, we need to have a competitive system. And so there's a lot of dangers here in what's going on. I certainly hope that the Supreme Court will agree with us that cable modems are a telecommunications service, that DSL is a telecommunications service. I hope that the court will also rule that as telecommunications services, that these companies have common carrier obligations, and that anybody, regardless of their message, regardless of their affiliation, should have some right to access to those lines. And that's really the fundamental issue here, is access to the lines and having competition in economics and competition in voices and ideas.
I want to thank you for expressing your ideas on these subjects to our listening audience and viewing audience today. And we'll get back to you as the case is decided and get your comments then too.
Well, thanks very much. We're certainly in suspense here. We're expecting a decision on this case sometime in the summer. We're pretty optimistic about the outcome. The hearing itself seems to have gone pretty well. The court itself seemed to be really questioning the idea that just because something was digital or bundled with a cable service, that it was no longer telecommunications. But we won't really know until the decision is out, so we're kind of in suspense until summer about that.
Okay.
So anyway, thank you very much.
You're very welcome. Thank you.